Good morning, good afternoon, or good evening, depending on where you're watching us. We'd like to welcome you to the second Quadcast Shipping Special. As with the first of our shipping specials, the problems we're about to discuss are set against the background of the current pandemic. However, the topics discussed are relevant in any situation where there's potential litigation arising in connection with letters of indemnity. By way of brief introduction, I am Nigel Cooper, and I'm joined by Chris Smith, Saira Paruk, and Paul Henton. Today, we're going to be looking at what can go wrong when discharge or delivery of cargo is made against letters of indemnity rather than bills of lading. The issues to be discussed are, of course, ones that we're all familiar with from our own practices. Before we get into it, just one note of housekeeping. There will be time for questions at the end, so please do post your questions using the Q&A function that should be available on your screen. And then I'll throw them out among the panel to be answered as we go at the end. So, letters of indemnity are, of course, an important tool enabling trade to keep moving in circumstances where shipping documents are delayed, often within the financing chain. That practical role is not new, but it has become even more important where COVID-19 and the global response to it has imposed delay and restrictions on the movement of trade. For example, the impact of the pandemic and the governmental response to it has meant delays in the banking chain, preventing the presentation of documents, and imposition of restrictions in ports have limited the options for discharge or delivery. In other words, there's been an increase in those situations where the owners wish to get the vessel out quickly, and charterers and receivers want to get access to the cargo as quickly as possible as well. But there's a perennial problem with letters of indemnity, namely that an owner ordinarily gains very little by agreeing to discharge or deliver cargo without production of an original bill of lading. On the contrary, the owner runs the risk of a missed delivery claim if he agrees to deliver against the LOI. And where such a claim arises, the unlucky owner will then look to enforce that letter of indemnity against its charterer, and so on down the chain of any subcharters. In other words, letters of indemnity claims which find their way to court will routinely involve multi-party litigation. So how do the claims play out? And perhaps more importantly, how does one avoid such claims in the future? Now, such questions aren't easily answered in the abstract. Luckily, or perhaps unluckily for the parties concerned, we've managed to identify an unlucky but entirely fictitious voyage which has thrown up a series of problems relating to the letters of indemnity passing down the chain. Sarah, I think this is over to you now to take us through the facts, please.
Thanks, Nigel. You should have received a copy of the case study in the Quadcast pack, but in brief, the facts of our case study are as follows. A were time charterers of the ominously named vessel, the MV Misadventure. A subchartered to B, who in turn subchartered to B. The subcharters were for a voyage to carry a cargo of iron ore from Brazil to Singapore. The charter parties allowed for discharge without production of the bills of lading against head owners' standard LOI wording, and head owners adopted the International Standard Group A wording for this purpose, and again you should have a copy of that in your pack. The vessel arrived at Singapore, but due to COVID-related delays, documents did not make it through the contractual chain in time. C requested delivery of the cargo to receivers without production of the bills of lading. The request was passed through the chain to head owners. Discharge was effected against a chain of LOIs as prescribed by the charter parties. The cargo was discharged by stevedores wearing full PPE gear. Stevedores were not arranged by head owners, and due to COVID restrictions, the crew had very little interaction with the stevedores. Head owners also did not ask too many questions. Their priority was to get out of Singapore because there was risk of further lockdown, and then their vessel would be stuck. The cargo was discharged without incident, and the vessel sailed for her next port of call. But when the vessel returned to Singapore some 4 months later, she was arrested by the receiver's financing bank, and damages were claimed for misdelivery against head owners. Head owners demanded that A put up security to release the vessel. This demand was passed down the chain to B and in turn to C. C does not respond. So what should head owners do?
Get the lawyers in.
Call the lawyers, exactly. Yeah, head owners should call the lawyers and say, well, we've handed over the cargo to a bunch of people in hazmat suits, and now we're staring down the barrel of arrest proceedings in Singapore. I suppose more pertinently, what do we do as lawyers? And nowadays, I think it's fair to say that we would be thinking of an injunction. And I think that we have put in a few citations to some of the latest LOI cases, authorities in our handout, which everybody participating hopefully has. And I think it's pretty well recognised nowadays that LOIs are an area where injunctions are granted and where damages would be an inadequate remedy in a lot of cases. And on the basis of the whole point of the LOI is to replace the secondary liability under any damages claim for detention by a primary performance obligation under an LOI. So I think maybe in some of the earlier cases, it used to be the advice that, well, you put up the security and then you look for declaratory relief or you look for damages or something. But nowadays, you would be clearing the desk and putting everything else on hold and looking to put papers together for an injunction. It's a mandatory injunction. It's not something you can really dress up as a prohibitory injunction. You're asking for a pretty draconian remedy, effectively compelling the issuer of the LOI to actually dip into their pocket and put up security. So for that reason, the cases establish that the owners or the applicant for the injunction will need to show, as part of the balance of convenience test, a high degree of assurance on the merits, a high degree of assurance that they'll succeed on the merits at trial. Basically what you're trying to show that the risk of injustice if the injunction is refused would be sufficiently outweighed by the injustice if it's not granted, and for that reason you need to, the court will be looking for you to establish a relatively high merits threshold at what is a relatively early stage of the litigation.
But Paul, you referred to a high degree of assurance and a high threshold. That, of course, begs the question, doesn't it, of what an owner or an applicant will have to prove just to satisfy that test.
No, absolutely. You throw one to Smithy?
Yeah, well, if I can kind of chip in on that point, essentially the owners have to show to the required standard that Paul's just described that the obligations in the LOI have been engaged. So you have to ask yourself, well, what is owner's side of the bargain in this regard? And if everyone can just track back to the wording of the standard form LOI which is in their packs, what owners have been requested to do, this is the first main paragraph, about 4 lines down, is they've been requested to deliver the cargo to X or to such party as you, the owners, believe to be or to represent X or to be acting on behalf of X. Now, the key word there is deliver said cargo. It's compliance with the request to deliver the cargo that triggers the numbered obligations you see below. That can be found from the words in consideration of your complying with our above request. So the owners need to establish a strong prima facie case that the cargo has in fact been delivered to X. Now that creates a bit of a problem for the owners. In modern shipping, delivery and discharge takes place at 2 distinct stages. Now, Nigel, who is a keen graphic illustrator, has produced a little something for us with a pictorial representation of these 2 stages.
That's just what you need silks for.
Drum roll.
Thank you very much. There you go. Beautiful.
Everyone can now see.
Yeah, and good luck, by the way, Nigel, with your graphic design GCSE results for coming out this week. So at the right arrow is the discharge stage. Now, this is the point where the owners hand over the cargo to the people in the hazmat suits. But as soon as the cargo is off the vessel will leave the port. However, delivery in the strict sense only occurs at the left arrow. Now, not only is that at a slightly different geographical location, but also with the goods going through the port, going through customs, passing through various different hands, it may occur slightly after discharge, by which point in time the vessel is long gone. I think that's enough of the diagram for the time being. So,
there you go.
Owners are in a position where they've discharged the cargo at the right arrow, but they've now left. The LOI refers to delivery, but they don't know what's happened between the right and the left arrow. What can owners do? Well, they can ask party A down the chain, say, what happened after we handed the goods over? Were the goods delivered to X? But by this stage in events, party A will know that the head owners are gearing up to get an injunction against them. And A won't offer up the information needed, which is just going to result in them getting the injunction against A. So A will quite often say, stum. One of the cases recently, the Universal Bremen about a year ago, that's exactly what happened. The parties down the chain who knew exactly what had happened just said, we're still investigating the position. They weren't going to offer up the information which would enable an injunction to be granted against them. So what can owners do to fill this information gap? The first thing they can try and do is maybe argue that the LOI is merely engaged by the discharge of the cargo on its true construction. This argument, though, isn't going to succeed. It was tried in the Bremen Max, and Mr. Justice Tier said in that case, well, delivery and discharge are two well-known, distinct concepts. The LOI refers to delivery, not discharge, and therefore the LOI cannot be construed as applying to discharge.
But how does that construction square with the fact that, you know, as we all know, the owner in this case won't exactly know, you know, to whom the cargo has actually been delivered?
Well, that is a difficulty for the owners, but it's mitigated to a certain extent by the wording of the LOI. If we just look back at it, everyone will recall that the owners are being requested to deliver the cargo to X or to the party that they believe to be or represent X. Now that dilutes the head owner's obligations somewhat, in that in the Zagora and in the Songa Winds decision, it was held that all that means that the owners need to do is have an honest belief that the party to whom they're handing the goods over represents X. Now, to take an easy and often too convenient in the real world example, that would mean that if the person with the hazmat suit comes on and the master or chief officer says to him, who is your principal, who are you instructed by? And they go X, the hazmat suit, then even if it's not in fact the case that they represent X, you've got enough information there for the owners to have the necessary honest belief. Now, obviously, that won't happen in most circumstances. In most circumstances, the guy in the hazmat suit is going to say, I don't know, I was just told to turn up and take this cargo. Or they might say, I'm instructed by Y, an entirely different entity. But in any event, those are the kind of problems the owner's going to grapple with at this stage. And then the main difficulty is for the owners to show that the LOI has been engaged. But I think for the purpose of this discussion, that's probably about all that we can say about it. And I think we should just assume for present purposes that the owners can show the compelling case that they need to show that the LOI has been engaged.
Yeah, no, exactly. But then on that assumption, I guess next question for the owners then is, who are they going to seek their injunction against? Do they join everybody, or do they go just against their counterparty at Saira Paruk?
Thanks, Paul. Well, the obvious answer is that head owners would go against their counterparty. So in this case, that is A. And they would seek to enforce the letter of indemnity provided by A by way of an injunction, as you said. A will then seek to enforce against B and B against C. These will be ex parte applications and will start off at least as 3 separate matters with 3 hearings. In our case, we are told that the letters of indemnity are on the same terms, the International Standard Group A terms. This includes, at clause 7, an English High Court jurisdiction clause. So that would allow for consolidation of all 3 hearings and matters. But as far as head owners are concerned, consolidation is not really in their interest, because they just want to claim against their counterparty, party A, get the security so their vessel can be released. because the longer this takes, the more costly it becomes. The real question for head owners is whether to put up security first before seeking an injunction. And it seems to me that the better approach is to seek the injunction first. I say this because once the vessel has been released, there may be a suggestion that when considering whether to grant an injunction, the factors such as urgency and whether damages are sufficient are affected. Arguably, there is no longer any urgency and damages could be sufficient because once the vessel is released, the owners can go about their business. In fact, Sir Ross Cranston in the Universal Bremen made the point in Overture comments, where he says that the purpose behind clause 3 of the LOI is to provide a means of swift relief where a ship has been arrested. That is, where a mandatory interim injunction is relevant. So if the vessel is no longer under arrest, the case for an injunction, perhaps at the very least, becomes less compelling.
Can I ask just a question there, Sarah? But that's kind of the position of head owners. What about A and B in the middle of the chain? I mean, what should they do? I mean, should they presumably be looking to pass the injunction on? Because they've obviously got some of the pressures of the head owners in terms of the vessel being stuck in hire or demurrage occurring, but also once the head owners have got an injunction, they're under threat of contempt of court, presumably, if they don't comply with the wording of the injunction, which will usually require them to do X, Y, or Z forthwith.
Exactly, Chris. So, as I said, it's not for head owners, and it's not in their interest for the matters to be consolidated, but it would be in the interest of the intermediate parties, so in our case, parties A and B, for the hearings and the applications to be consolidated at the return date. First, it seems like a proportionate way to move forward, but we should note that it would only work if the LOIs all have the same jurisdiction clause. In fact, this is what happened in the case of the Miracle Hope earlier this year. In the usual way, the injunctions were granted down the chain. The parties in the middle wanted to have the matters consolidated so that they could simply pass the demand along and drop out. But that then raised the issue of timing. In our case, if A has an injunction against it, if they don't comply with it, they will be held in contempt. But they, in turn, want to pass it down the chain. So, as you mentioned, Chris, the injunctions had the wording that security should be put up forthwith. And if that's not complied with, then obviously party A would be in contempt. So the question arose as to what forthwith meant. Does it mean immediately without regard to practicalities of doing so? Or does it mean in the shortest practicable time? The answer came back that it was the second of those, the shortest practicable time, which in turn depends on the facts of the case. So the answer to Chris's question is that the intermediate parties need to apply for their injunctions quickly enough so that they're not in contempt, so that they can then argue that it's not us who should pay, but in fact, in this case, it should be party C.
Yeah, then you have another issue as well, which is that the parties further down the chain start to argue that they're discharged from their obligations under their own LOIs if security has been put up by a party further up the chain from them.
Well, that's a good question, Paul, and it reflects a line of argument that was run by one of the sub-charterers in the Bremen Max. This is probably a good moment just to remind ourselves that the international group wording, clause 3, requires a party requesting discharge against an LOI, in paraphrase, to provide on demand such bail or security as may be required to prevent the arrest of the vessel or obtain her release. And the argument put forward by the subcharter in the Bremen Max was that this wording only required a party to put up security if it had not already been put up by another party in order to obtain the release of the vessel. If the vessel had already been released, it was said, there was no longer an obligation to put up security. But this argument received short shrift from the judge. Mr. Justice Tier held that an LOI imposes a primary obligation on a charterer to put up security to prevent arrest or to obtain the release of the vessel in the event that the vessel has already been released. If an owner has already had to put up security, that fact does not release the charterer from its primary obligation. On the contrary, while the action of an owner in putting up the security may have mitigated its loss, the charterer remains in breach of its obligation under clause 3. And that breach isn't discharged by the owner putting up security. What the court said was that were it to be otherwise, the commercial purpose and intent of the LOI would be frustrated. And it's in that context that Mr. Justice Tier went on to hold, in this circumstance, that the appropriate remedy was to order specific performance and require the charterer to provide replacement security. And I agree with Sarah that you've always got to satisfy the test for an injunction, whether on the balance of convenience there's sufficient urgency and whether it's necessary. But it is clear from the authorities that the courts are going to look to specific performance as the remedy to be granted if a charterer or sub-charterer down the line is not putting up security where they should do. But there's then the question, to whom is the security to be provided? If it's being provided by a party further down the chain, do they provide that security to the party immediately above them in the chain, or do they have to provide it directly to the arresting party, usually a bank, either in the form of original security or as replacement security? Now, clearly the former would lead to a potentially bizarre situation where you have several sets of security in place, possibly on different terms, certainly from different providers, and obviously on our facts, there'd be at least 4 sets of security. Now, there's no direct authority, no direct case law which discusses the issue in any detail, but the trend of the case, it certainly suggests that there should only be 1 set of security in place. In the Bremer Max, the issue was one which was to have been decided by Mr. Justice Tier, but before he gave judgment, the parties had accepted among themselves that the security was going to be provided directly to the arresting party. More recently in the Universal Bremen, Sir Ross Cranston granted an application that the sub-charterer should provide security to the arresting party and rejected an application that it should be provided up the chain, but without discussing the issue in any detail. I have to say that in my view, the requirement for only 1 set of security is the only answer, security directly to the arresting party, is the only answer consistent with the intent and purpose of an LOI, because it's for the party providing the indemnity to take the burden and responsibility of the risks prevalent in the release of the cargo against the letter of indemnity. Now, this does, of course, mean that the party providing the security will not have control of the claim and of events in the arresting court. But that's a point we can return to later on.
So then the next question is, what form should the security take? Is it the case that whatever the bank wants, whether it's a bag of diamonds or the cash, that they get?
So I'll deal with this one. Yeah, I mean, well, so that was one of the points that was touched on in the Miracle Hope case, 2020 case, the last of the cases listed on our handouts. I think in the third of the judgments cited there, which was the return date. So I think you had 2 ex partes, and then you had a return date with everybody involved, and that was judgment was Justice Tier, and there were sort of 3 possibilities considered. The first is the one you mentioned, Sarah, that whatever the bank wants, the bank gets, and the obligation is to provide whatever it takes to satisfy the bank, and that one was rejected. And then the other 2 options were either that it's a matter for the court in the arresting jurisdiction to determine, or that it's a matter for the commercial court, as the court seized under the LOIs. And Mr. Justice Tier held that it was the second option. So in our case, it would be whatever the court in Singapore orders. And so I think because we've got a friendly jurisdiction, I don't think it necessarily poses too many difficulties. And I think also, most cases, obviously, there'll be discussions with the arresting party. And again, we've got a bank here arresting in Singapore. But obviously, option 2 opens up to the difficulties a lot of us have seen in practice where, the arresting jurisdiction is one which will in turn bow to the demands of the arresting party. I think the answer must be right. It's consistent with the requirements of the Arrest Convention. I think the commercial court will have jurisdiction over the question, but will in practice refer it back to whatever's been ordered by the arresting jurisdiction. Okay, well, new topic. Should we now look at some of the insolvency situations? I think we're told that C might be a man of straw in our problem. So what happens if C doesn't comply with the injunction?
Well, clearly, Paul, the first situation in which this can arise is if C or another party in the chain is insolvent, as you've mentioned. There may be other reasons why C doesn't comply, whether or not it's because they have no identifiable assets, whether they just simply fail or refuse to comply with the order to put up security. Chris, what happens then?
Yeah, well, I mean, obviously, if C's insolvent and that's proven established, there's insolvency measures. In one sense, the position's quite clear. C's not going to put the money up. But quite often you get the scenario where C effectively prevaricates and says, oh, I'm trying, or oh, I don't have the money, without putting proof. In many other cases, C just simply takes the view, well, my assets, my officers, they're outside of the reach of the English court, so I'm not going to respond. And that's a situation Paul and Nigel are very familiar with, because that's exactly what your clients did in the Zagora, if I remember rightly.
Possibly comment, Chris.
Yeah. But anyway, it's all the same position, whether or not C has a good excuse or not for not complying with the injunction. That suddenly puts B in a bit of a quandary. The minute A got its injunction against B on our sample facts then went and got an injunction against C. Now, at that point, B could have perhaps rested easy, at least for a moment or two, thinking, okay, I've got an injunction against me, but I've now gone and got a like one against C. C will put up the security, phew. But if C doesn't play ball or is insolvent, etc., the question arising for B is, well, what do I have to do now? Have I complied with my obligations under the injunction simply by virtue of the fact that I've gone and got an injunction against C myself? Well, the answer to that, I think, must be no. Assuming the injunction has been properly drafted, it will require B forthwith to take such steps as are necessary to secure the release of the vessel. Not to take one step, which, even if it's not successful, that's good enough for you and you can down tools. So B is suddenly now on the horns of a dilemma where the one attempt it's taken has failed, and it's now at risk of being in contempt of court because it hasn't secured the release of the vessel forthwith. The answer in that scenario, I think, is that B suddenly now has to stump up the cash and take steps to get the vessel released itself.
Yes.
B is now the party at the end of the chain, effectively.
In fact, yeah, I mean, so for those who are watching and listening in and don't know, the case that Chris mentioned, the Zagora, was one where I think Nigel's clients were at the bottom of the chain and took the view that they were beyond the reach of the courts, and so sort of dropped out of the litigation at quite an early stage. My clients were a party in the middle, and in accordance with Sarah's very prudent advice earlier, the party in the middle adopts a back-to-back position, and so we probably did precisely the same thing as Nigel Cooper's clients and also dropped out, leaving Chris's party as the sort of the new party at the end of the chain. I suppose the other insolvency scenario or man of straw scenario that we then have to think about would be, well, what if it had been a slightly different scenario? What if the owners had gone after Nigel's clients because it was Chris and my clients who were dropping out of the picture? So in our example, what if C is the party of means, the commodities house, the receiver with the money, and it's the parties in the middle who are the men of straw with no identifiable assets or the flight risk or the out of the jurisdiction party. So that's sort of the second insolvency scenario. Sarah, why don't you take that one?
Thanks, Paul. In short, head owners in that scenario, so if party A or party B were insolvent or men of straw, head owners could claim directly against C or B, as the case may be. And that's by virtue of the Contracts Rights of Third Parties Act 1999. There aren't many cases that deal with this actually, but in the Lemthong Glory, the standard international wording which was used for the letters of indemnity in that case was held by the Court of Appeal to confer a benefit on owners as agents of charterers. So if you look at the standard wording, the letter of indemnity is actually addressed to charterers, their servants or agents. So it was held that in delivering the cargo, owners are actually acting as charterers' agent, as charterers have no obligation to deliver themselves. So the court held that the wording of the LOI fulfills the requirements of section 11B of the 1999 Act, and thus owners could take the benefit of the letter of indemnity further down the chain, even though they weren't a direct contractual party to it. In our case, the same wording applies. So owners could bring a claim and an application for an injunction against B if it was A who was insolvent, or even against C if that was deemed worth it. The other case that deals with this point is the Jag Ravi. In that case, the owners brought a claim against charterers and receivers. Charterers played no part in the trial as they were in liquidation. At first instance, His Honour Judge Mackey QC held, in line with the Lemthong Glory, that given the wording of the LOI, again it was the standard wording, owners could enforce the letter of indemnity directly against the receivers, again by virtue of the 1999 Act. The Court of Appeal upheld that decision, but their reasoning is slightly less clear. The Court of Appeal put more emphasis on the fact that in their case, the letter of indemnity from receivers was expressly addressed at the top of it to charterers and owners. So it could have been that it was held to be a tripartite contract. However, Lord Justice Tomlinson also expressly stated that he agreed with Judge Mackey at first instance. So it's not clear exactly the basis on which it was found that a direct claim could be brought against the receivers. But in any event, it seems that where the standard international group wording is used in terms of clause 1, the 1999 Act can provide parties a way to leapfrog those who are no good for the money.
Thanks, Sarah. Well, as hopefully we've shown just in the half an hour so far, there are a fair number of knotty issues arising. Now, the points we've covered in this element of a webinar have been almost like the greatest hits. And we can get on to some of the deep cuts a little bit later in the Q&A session and deal with some of the issues that arise after the injunction's been granted and after the vessel's been released. I mean, one of the points that the courts still have to work through is what the position is on claims control. Who is going to direct the defence of the arresting party's claim for misdelivery? And what happens if they do a bad job of it? Does that affect the obligations of the party down the chain who may have put up the security? These are all points we can dive into if needs be in the question and answer session, if anyone's interested. But before we get on to that,
post a question on the Q&A. We've got 6 so far, so
that's very exciting. But before we get on to the Q&A and those 6 questions, I think, Nigel, you've got a few suggestions for avoiding pitfalls in the future.
Yeah, thank you very much, Chris. As you say, we can get some of the knotty problems under questions, and there are certainly some good ones there so far. But what of the future? How does one avoid claims? As judges say time and again in cases on all sorts of contractual issues, it's all in the wording. As the case is repeatedly emphasised, the parties' rights will be determined by the proper construction of the wording of the LOIs. And in this regard, as an intermediate party, it's essential to ensure that the LOIs are on back-to-back terms, so as to avoid a situation where the chain of liabilities ends prematurely before they reach the party ultimately intended to receive the cargo. Now, typically the wording of the LOI will be agreed between owners and their charterers at the time of the charter, and then it's taken down the chain. As to the form of the LOI, the International Group A standard wording, which you have in your packs, is clearly a good starting point. But as with any standard form, one needs to ask if it will be enough in its unamended form. And some of the points to consider that arise from what we've discussed are as follows. So the beneficiary of the LOI. As an owner or time charterer, one may wish to protect oneself against the risk that a party further down the chain becomes insolvent and breaks the chain. As Chris has pointed out, an LOI addressed to the charterer, its servants or agents, will also allow a party higher up the chain to rely on the LOI, on an LOI lower down in the chain as a servant or agent of the charterer. And therefore, it's important to ensure that that wording is going to be incorporated in LOIs down the chain. Secondly, there's the question of when the obligations under the LOI are triggered. And we will be coming back to this in the questions. It's essential to have clarity about which operation is going to bring to an end owner's responsibility for the cargo and bring into play a charterer's obligations under the LOI. From an owner's perspective, it may well be that discharge of the cargo is the critical point, critical moment, and the standard wording needs to be amended to trigger obligations at the point of discharge. From a charterer's point of view, it's likely to be advantageous to insist on the unamended form of LOI, which responds to delivery. Either way, ensure that there is clarity about the point in the operations at which the indemnity is to bite. Thirdly, is the person to whom the owners are to release the cargo properly defined? Is the recipient to be a named person only, or are owners to have the benefit of the proviso that they can deliver to such party as the owner honestly believes to be or to represent the named party? Either way, as charterer, one may wish to consider whether to include an obligation on the owner to verify the identity of the party to whom it is delivering or discharging the cargo. Of course, one would expect a prudent owner to do this anyway, because some attempt to verify the identity of the party to whom they're handing over the cargo is going to be important in establishing an honest belief that they have handed it over to the right person. Depending on the nature of the cargo, consider whether one requires the deeming provision in clause 4 of the standard wording, allowing delivery to be made to a terminal or other facility, ship, lighter or barge. There may well be circumstances where it makes sense, certainly from a charterer's perspective, to delete this provision to ensure delivery to a named party only. And then finally, let's go back to the point that Sarah made quite early on, namely ensure that the law and jurisdiction provisions through the chain of the LOIs are the same. Owners may consider consolidated proceedings to be an inconvenience, to say the least, but one does not want to be a party further down the chain who finds themselves forced to litigate in a different jurisdiction because different law and jurisdiction provisions have been agreed. Now those were my points. Does anyone have anything to add before we move on to questions?
Not from me.
It's Q&A.
Q&A. Okay, well, we've certainly got a fun one to start with. So the first question, would the transmission and receipt of the bills of lading by electronic admission, for example, ESS docs, change the situation? So I anticipate that means, would it change the rights and liabilities of the parties?
Well, presumably it would change the situation in the sense that it would minimize the risk of delays in the banking chain of the bills of lading being transmitted. And that might mean we never get to this scenario in the first place. But otherwise, the kind of issues we've been talking about, delivery, discharge, security, etc., I think are unaffected by that possibility.
Yeah, exactly. The issue here is that the LOI is an independent contract separately from the charters in chain or the bills of lading or anything else. So electronic transmission, as Chris, as you say, hopefully leads you to a situation where you're not litigating under a chain of back-to-back LOIs. But if you are, then you're under independent contracts. And so these issues are still all going to arise.
Well, I think from the nodding and from the answers we've had so far, we're all in agreement. The starting point would be, I think, the one that Chris made initially, which is that we're unlikely to that it is less likely to come to a point where one needs letters of indemnity if the documents are being transmitted electronically. We then have a question relating to what happens under sale contracts, which require letters of indemnity. For the cargoes where similar questions arise under the letters of indemnity for carriage. And the question's in these terms. C may well have a CIF contract with receivers who have to pay again against an LC against documents such as bills of lading. That sale contract could similarly have an LOI provision to enable payment. In the context of that LOI, presumably the case law relating to delivery and discharge is different, as delivery in the sense of the sale contract occurs at the load port. Who wants to take the running on that one first?
Well, obviously, I'll have a stab. I mean, it's obviously a different scenario, because in the one that we're dealing with, the ship owner is being asked to breach the bill of lading contract. And the ship owner is being, because under the bill of lading contract, the ship owner has to deliver the cargo against production of bills of lading. The ship owner is being asked to do that. The ship owner is therefore running the risk of misdelivery and the risk of the ship being arrested. And it's those risks that the LOI is intending to kind of like hedge against and to give the ship owner protection. Now, in this scenario, under the contract of sale, what effectively the seller is doing is it's giving up its security for payment for the goods in the form of holding the bills of lading, and it's doing so in return for an LOI. Now, presumably an LOI on those terms would have different protections in place and would be concerned with a different scenario, namely whereby the seller releases the bills of lading, the buyer gets the goods, but the buyer then subsequently doesn't make payment. Now, in that scenario, as I believe it was David Clark says, well, you're not really arguing so much about what delivery means, because delivery's already occurred. But what you are going to be arguing about is whatever the LOI says has to be done. Please provide the cargo to X, because there must be a physical handing over of the cargo or the bills of lading in order that's being offered up by the seller in return for the LOI. Has that been done? And if it has been done, what are the obligations the buyer is then saying it's going to do? And it must be something more over or on top the ordinary contractual promise it has to pay for the goods. What further obligations is the buyer offering in the LOI? And can you secure performance of those obligations via an injunction? So all of which will raise similar-ish questions to our ones, but it'll be more focusing on question of delivery of the bill of lading rather than delivery of the goods.
Yeah, I think that's right. I mean, I think what one can say, though, is probably that the authorities that we've been discussing maybe of assistance by way of guidance as to the approach to take to construction of the LOI, the process of construction, if not directly relevant to what are the obligations of the party under the bills of lading, under the letters of indemnity.
Come on, Quizmaster, give us a hard one.
Q9 is a good one.
The question from Mr. Shamayo raises any different point. I think it's a question in similar terms. Good morning. How do you see the interrelation of LOIs issued by seller charterer in the context of sale contract? Even though we see more and more cases where seller, even though they've not been able to present the bills of lading for payment, and issue an LOI, but at the same time ask a counter guarantee from the buyer as no bills of lading are available at the discharge port. Yeah,
I'd seen Benoit's question when answering the original one from David Clark, so I tried to encompass that in my answer. So, I mean, hopefully, Benoit, if you're listening, we've dealt with your point. If there's any more specific you want, then obviously the Q&A session's open for a while yet, so fire another question in.
Yeah, I took the same view, Chris. I think your answer, or the answers we've given have covered that off. But if there is any further point, then please ping us another question. So the next question concerns the sketch that I put up earlier. So I'll just put it back up and ask the question of what actually happens when a dry bulk cargo, such as INR, or in this example, is discharged onto a quay. According to most charter parties, that is the end of the obligation of the head owner or disponent owner, who is not involved with the overland movement of the cargo to its interim or final recipient. So who wants to take that one?
That may be raises an issue of differences between rights and obligations under the charter party and obligations under the LOI, which, as you said, is a separate independent contract. And look, to be clear, you can negotiate for an LOI which bites on discharge only and not delivery. So that that power is with the contracting party if you can get that, and then the obligations are at an end on discharge. But ultimately, if you've for a string of LOIs which operate on delivery, then we're going to have this issue, almost regardless of what the obligations under the underlying charter parties would be.
And obviously it has to be remembered that the very reason the LOI is needed is because whilst the obligations under the charter may be satisfied by discharge onto the quay, the position is not true under the bill of lading, and that's why the ship owner needs an LOI, because the ship owner still owes obligations under the bill of lading, which is potentially being asked to breach.
Okay. Now we're coming to a couple of questions that concern the proceeding, the arrest of the vessel, or the request for security by an arresting party. The first of which is, what happens if the arresting party won't accept security from a charterer or sub-charterer down the chain?
That's kind of the miracle hope point that we were talking about earlier, with the the unreasonable security demand and who is the deal breaker in that situation. So in your ordinary case, what's being put up is probably a bank guarantee security, something like that. And so for the recipient of the LOIs, or for the bank to just say, no, we won't accept that from C, we want it from B or A, sounds like the sort of unreasonable response. And then that's one which then ultimately the court has to decide what's reasonable security, on the facts of the case, and deferring that to the courts of the arresting jurisdiction as necessary.
Yeah, so I was just going to say that I think that is a question for the court of the arrest, because that court will determine, presumably, whether sufficient security has been put up so that the vessel can be released.
Yeah, indeed, and I guess the issue that the interesting issue is where you have, I will not accept security from this entity, and perhaps in some of the more esoteric jurisdictions, so not Singapore like we've got in our case, but in certain other jurisdictions where, well, the arresting jurisdiction are happy to go along with whatever the party, the arresting party wants, and then whether the commercial court then steps in and imposes its own standard of reasonableness above and beyond, or whether it's simply just defer to the arresting jurisdiction. And so far, the answer that the courts have given back has been we defer to the courts of the arresting jurisdiction, obviously for reasons of comity and so on. Mm.
But that might impose a position, therefore, that for the owner, that if they've got an order from the English court requiring security by the subcharter to be put up directly by the subcharterer, but the bank refuses, and the arresting party upholds that refusal by the bank. Sorry, the arresting court upholds that refusal. Then the owner is, of course, going to have to come back to the English court and seek a variation of their order. Perhaps at that point asking for security to be given to it in relation to the security that it's had to put in place in the country of arrest.
I think in the Miracle Hope, I think the reason why the judge, I think Miss Justice Tier, got involved in this question was because it was thought that the courts in Singapore couldn't deal with it because they were locked down, and he didn't want there to be a delay. So I think that's why he got involved in this question at all, as to what sufficient security would be, because I think the primary position is that it is a question for the court of the arresting party. So there are quite particular factors as to why it was an issue at all, actually, in the court here.
I'm just going to pick up one of the questions a little bit further down the chain, because I think it arises in this context as well. I mean, it comes back to the point that Chris raised earlier, namely, who directs the defence in order to avoid prejudicing a party's rights under the LOI? And I read that as being a question for who deals with control of any proceedings in the arresting court.
Yeah, I can pick up that because I kind of trailed that as a problem a bit earlier. Obviously what's happened in our scenario and in most of these scenarios is the arresting party, quite often the bank who's got the bills of lading but not being paid, is arresting the ship, the head owners, the party to the bill of lading, and is bringing a claim for misdelivery. So the direct claim is going to be bank arresting party against carrier, normally the ship, under the bill of lading. Now, but what happens if C's put up security down the bottom of the chain? C's not the one being sued by the bank, but C's the one who is financially on the hook. Does C have a contractual right to say to the head owners, oi, because I'm the one who's financially on the hook, even though you're being sued, let me and my lawyers take care of the defence of this claim? Now, it's a point that's not really been properly worked through yet by the courts. I mean, Songa wins, there was an argument about it, but Mr. Justice Andrew Baker effectively said that he was encouraged that the parties seemed to be working towards a consensual solution. And in the Universal Bremen, Sir Ross Cranston, again in a bit of a one-line bit of the judgment, simply says, well, you've got no rights in that regard to the party in C's position. So legally, I think the position is that the parties down the bottom of the chain who put up the security don't have a contractual right to direct the defence of the misdelivery proceedings. Practically speaking, they're often given that right by the parties up the chain, but I'm not sure they have the right to demand it. Now that gives on then to a follow-on question, which again is quite knotty and hasn't been worked through. Well, let's say the head owners refuse to hand over conduct of the defence to C. Head owners do it, but because financially they don't really have any skin in the game, they don't do a very good job of it. And as a result, the misdelivery claim succeeds to a greater extent than it ought to have done, such that C is liable under its security in a greater amount than it ought to have been. What happens there? Does C have a right to recover the excess amounts that it's been held liable for? And to be honest, who knows? I mean, is there a term of the letter of indemnity that allows them to recover? Do they have a common law right for negligence?
Or something under the chain of charters, duty to cooperate, something like that.
Exactly. I mean, these are all the points that I think of all the remaining issues that haven't really been ventilated at all in relation to these letters of indemnity. That's the major one awaiting consideration from the courts.
And then the practical advice, I suppose, for people watching, listening in, thinking about these issues is to try and get it bound up in your security arrangement. So if you have an escrow agreement or I'm going to put up security in exchange for that, I want claims control, or I want witnesses, or I want access to documents, whatever it might be. And
probably if you can't get it agreed formally in the security arrangements, it's certainly something you would be ventilating at the at any court proceedings relating to the grant of an injunction, essentially to put the owners in a position where they've got to acknowledge that they will take into account the views of other parties who are required to put up security.
Absolutely. As regards Paul's suggestion in terms of asking for it, I think a practical point to make is the party in C's position is going to have a stronger bargaining chip to play if the injunction has not been granted. So if they're negotiating for the provision of security before the injunction's been granted. Once the injunction's been granted, they've got very little by way of bargaining heft at all because they have to comply with the order forthwith. So head owners can say, no, there's nothing of that in the order. Put up the security now, please.
Well, unless they're going to pull the Zagora trick and say we're outside of the jurisdiction and we're not complying with this injunction.
Yeah, quite well, in which case, though, claims control becomes irrelevant.
Let's move on to something else. We've had quite an interesting one. Is there any duty on the rightful consignee of goods to somehow advertise the fact so as to put others, for example, the ship owner, on notice that if they deliver to any other party, they will in breach, or to contact the ship owner directly? Anybody got any views on that one?
Well, no. When I saw that question, my immediate thought was, normally at this stage, the party the rightful consignee, so to speak, by which I presume the questioner means the party holding the bills of lading is the bank. And it would be very rare for the bank to get involved at this stage. But let's say the bank was aware that this was going on, that the LOIs were being issued, and there was the prospect of the cargo being released before the bank could be paid. if the bank then said to the ship, said to everyone involved, I hold the bill of lading, do not deliver the cargo, I will sue you for misdelivery, then I think there would be an argument there that the owners, not just they wouldn't be obliged to comply with the LOI and deliver the cargo without the bill of lading, but actually they'd be committing an unlawful act, notwithstanding what they've said they would do in the LOI, if they handed over the cargo in those circumstances, because they'd be on notice of a conversion claim, and so they'd be on notice that the act they're being asked to do in the LOI is an unlawful one. So
I think that's a point that the lawful consignee or the bank, that's something they can do to protect themselves, but I don't think they have a duty to do so.
No, absolutely not.
Yeah,
right.
I think it then goes back to whether the ship owners can say that they reasonably honestly believed they were giving it to the right person. So, like I said, there's no duty on the consignee, but if by doing that they take away an argument that ship owners would otherwise be able to raise.
Well, I think it's good that you're online, as it were, Sarah, because I think the next one we'll throw your direction first, because I think it falls under what you were talking about. Referring to the scenario at hand, if C's LOI expressly excludes the rights of third parties, can the head owner still reach past B directly to C in circumstances where the LOIs up the chain are on standard terms?
My answer to that is yes, you can expressly exclude it, so then owners wouldn't be able to leapfrog or reach past B. And the reason I say that is simple application of the 1999 Act. The way that the 1999 Act comes in is that you've got to show that the term that you're trying to rely on, that grants you your relief or the obligation that you're trying to enforce, is it purports to confer a benefit on the third party. If there is something in the contract that derogates from that, so expressly says that it doesn't purport or doesn't confer a right on the third party, then the Act wouldn't apply. So yes, you could expressly exclude the application of the Act.
Okay, I think we have got a number of questions still outstanding, but I'm going to apologise to all those who've asked questions that we haven't got to. If there is anything anybody in particular wants to follow up, please do let us know and we'll see what we can do afterwards. But one final question. I commented that an LOI triggered by discharge may give owners better protection or be easiest to operate. Even after discharge, however, does the owner still not continue to be responsible to ensure proper delivery of the cargo to the party entitled to it? Discharge is not equivalent to fulfilling the bill of lading contract. Does anybody else want to comment on that?
Well, just other than to make the point that that's obviously absolutely right. Discharge, well, unless you're discharging to the party named in the bill of lading, discharge does not fulfill the bill of lading contract, but that's what gives the very need for the LOI in the first place, because the head owner is being asked to breach the bill of lading contract. Yeah,
so the head owner may still have a liability to the bill of lading holder if it's found to have discharged or delivered the cargo to the wrong person. But if the LOI provides for release of the cargo against discharge, the head owner would be able to look to the indemnifying party and seek an indemnity in relation to any liability under the bills of lading.
Yeah, and obviously the situation envisaged by the questioner, I mean, they're obviously right, but I think the point you were making earlier, Nigel, was just that if the LOI is triggered by discharge, you don't have any of the difficulties of proof.
Yeah.
You just have to prove that you discharge the cargo, which will be the easiest thing in the world for a ship owner, you would imagine.
Hope so.
Gave the guys in the PPE. Job done.
Okay, ladies and gentlemen, to all of those of you still online, thank you very much for joining us for this Quadcast. We hope you found it interesting. If you want to watch this one back, or indeed catch up on any of the other editions, please do go to the Quadrant Chambers YouTube channel. And can I also finish with a plug for the second issue of Quadrant on Shipping, which is now available. If you haven't received it and would like to do so, please do get in touch with Sarah Longden. Thank you very much from me for watching, and goodbye to everybody. Hopefully we'll see you at a later Quadcast.
Thanks very much.
Thank you, everyone.
Thank you, everyone. Bye.
Bye.